Hi there. Good morning, good afternoon, good evening, whatever time it is. As always, happy whatever day it is that you are watching this, which is what's left. That's what you're watching. I'm your host. My name's Larry Erickson, and for the next half an hour, we're going to be talking about a couple of things that I think are worthy of your attention that could actually be quite important to you. So stick with us if you would. As always, if you have any reactions to the show of any sort, you can email them to me directly. This is my personal email, whoviating@aol.com. And if you didn't catch that, you can go to my website, which is called Lotus Surviving a Dark Time. The URL will be here a couple of times during the show. You can get the email address from there, or you can leave a comment there if you'd rather do it that way. If you do send me email, as always, I have two requests. One, includes something in the subject line that makes it clear it's about the show, it's not spam. And two, be a little patient about getting an answer, but you will get one. All right, with that, let's get to it. I always like to start with some good news, and I got some, although there's sort of a theme here that you're going to see developing. In the first case, I've got good news arising out of bad news. On October 20th, 2014, a Chicago cop named Jason Van Dyke killed Laquan McDonald. More than a year later, a suit forced the city of Chicago to release the dash cam video of the incident, which proved beyond doubt that McDonald was walking away from Van Dyke when Van Dyke shot him. And then as McDonald lay on the ground, Van Dyke proceeded to shoot him 15 more times. When the video came out, Van Dyke was charged with murder, 6 counts of murder, and more recently was 16 counts of aggravated battery with a firearm. His trial, though, has yet to begin almost 3 years after the incident. All right, so what's the good news here? Last month, 3 Chicago cops were indicted on state felony charges of conspiracy, obstruction of justice, and official misconduct for conspiring to cover up the facts of the shooting through mishandling of evidence, lying on official reports, lying to the medical examiner, and various other means that they did to try to keep this a secret. The 3 involved are Detective David March and patrol officers Joseph Walsh and Thomas Gaffney. They did this in order to keep the public from seeing the video because they knew that when that video was seen, it would lead to an investigation and probably criminal charges against Van Dyke. So the good news here is that as the result of the tragedies and protests of the last few years, we as a society seem to be a little more willing to at least consider holding cops responsible for their actions. And the fact that this particular indictment is a direct blow against the blue wall of silence makes that even better. Unfortunately, while we seem to have gotten a little better at charging cops when they needlessly kill people, we seem to still have a great deal of difficulty in actually convicting them for it. So consider this very tempered good news. Another bit of tempered good news on a somewhat related topic. On July 7th, a panel of the Third Circuit Court of Appeals ruled unanimously that the First Amendment does provide an individual with the right to film police officers performing their duties in a public place. They found that, quoting the decision, the First Amendment protects the public's right of access to information about their officials' public activities. The Third Circuit now joins the 1st, 5th, 7th, 9th, and 11th Circuits in concluding that the Constitution guarantees such a right to record, as it's called. No federal appeals court has ruled the other way. All right, so why is this tempered good news? Well, for one thing, cops keep doing it. They keep telling people that they, the cops, are exempt from being observed while in public by mere non-cops. They keep arresting people, even assaulting people, even destroying cameras, because apparently we're supposed to walk around with our eyes constantly cast downward and never record anything a cop does, except, of course, for the planned PR stunts. Even more. The Circuit Court also decided, in this case by a vote of 2-1, that the 2 Philadelphia cops involved in the case have what's called qualified immunity against suits, meaning they walk away untouched, because the right to record, it said, was not clearly established at the time of these incidents. And they ruled that way, even though at the time of the incidents involved, 3 circuit courts had already found a right to record, and again, none said the other way. And more importantly, the Philadelphia Police Department had already acknowledged a right to record. Which, by the way, this is another reason why the cops keep doing this kind of thing. They have learned, like the most cliche spoiled brat, that there are no consequences for misbehavior. Still, there is the actual decision about the right to record, so I guess I'll have to consider that good news. Tempered, yes, but still good. Okay, continuing with the theme of tempered good news, I think I told you a while back about the case of Desiree Fairooz, a Code Pink protester who made the mistake of letting out a quick laugh during the confirmation hearings as Attorney General of Jeff, I am not a racist, I swear, Sessions. Astonishingly, she was convicted of laughing. The good news is that on July 14th, Chief Judge Robert Morin of the Superior Court of the District of Columbia overturned the conviction. The tempered part here is that he did it because the prosecutor had said in closing arguments that the laugh alone was enough for conviction, not any disruption she may have caused while she was objecting to being dragged out of the visitors gallery. The judge said the laugh alone was not enough to send the case to the jury, but instead of dismissing the charge, he set a new trial for September 1st. So now the prosecution has a second chance to achieve the same goal, punish her for laughing, now with the guidance from the court as to a good way to get around to be able to do that. All right, finally, one more bit of tempered good news. Okay, first, last month, the Supreme Court partly revived TheRump's 2 stalled travel bans, one of which is against people from 6 majority Muslim nations, those being Iran, Syria, Somalia, Sudan, Syria, and Yemen, and the other one against refugees. The High Court said that those bans could go into effect, but would not apply to people with a bona fide relationship to a U.S. person or entity. The Rump goons naturally interpreted that provision very narrowly, saying it only applied to people with a parent, sibling, spouse, child, adult son or daughter-in-law in the United States. Well, federal judge Derek Watson in Hawaii found that description to be much too narrow, and citing the more expansive modern understanding of the term family, he broadened the interpretation to also cover grandparents, grandchildren, brothers and sisters-in-law, aunts, uncles, nieces, nephews, and cousins of those in the United States, which is clearly good news. When the Rump goons went to the Supreme Court looking to get that ruling overturned, they were rebuffed. Which is also good news. The tempered good news, however, is that they were only rebuffed on the part of the travel ban applying to travelers from those 6 majority Muslim countries. The justices did not uphold Judge Watson's ruling on those. Rather, they put a hold on his ruling as it applies to refugees, while the Ninth Circuit Court of Appeals considers a separate appeal on the same issue. So the narrow interpretation still applies to refugees, which does temper the good news of continuing court resistance to the Rump's paranoid bigotry, but doesn't deny it. All right, now going to one of our regular features. We didn't get to this last week, but it's back, and it seems to be actually, based on responses, possibly our most popular feature around here. It's the Clown Award, given as always for an act of meritorious stupidity. And we had some solid competition this week. So I'm going to list off our 4 finalists in their order of finish. Bringing up the rear, which is appropriate because he's a real ass, is Representative Steve King of Iowa, a bigoted white supremacist who was surely in the running for being the worst person in the world. Not surprisingly, he wants to build that wall. Well, the House Appropriations Committee has proposed $1.6 billion to get that started, but that's enough for I Would Be King. He wants an additional $5 billion for the wall in the budget, $500 million of which is to be taken from Medicaid reimbursements to Planned Parenthood, and the rest coming out of food stamps, which he considers a good thing because food stamps are what's causing obesity. Frankly, if he really wants to reduce obesity, he could start with the fat in his head. Next up, in third place, there is Representative Dana Rohrabacher of California, who seems to have embraced the "I'm not a scientist" mentality of the right wing with a little more than the usual enthusiasm. During a hearing of the increasingly misnamed House Science Committee on NASA's budget for planetary exploration, Rohrabacher, who, Lord help us, is on the committee, asked NASA scientist Kenneth Farley, quoting here, "You have indicated that Mars was totally different thousands of years ago. Is it possible that there was a civilization on Mars thousands of years ago?" Farley politely noted that it was billions of years ago, not thousands. And when Rohrabacher persisted, gently as you would with a child, said the chances of a Martian civilization in the past are extremely unlikely, quote unquote. Would that was equally true of people like Rohrabacher. All right, here the competition, however, gets stiff. On July 2nd, longtime Clinton family ally and advisor Paul Begala was grousing on CNN that the Rump supporters don't seem sufficiently outraged about claims of Russian meddling in U.S. affairs. He fumed that, and I'm quoting, "We were and are under attack by a hostile foreign power, and we should be debating how many sanctions we should place on Russia or whether we should blow up the KGB or the GRU, the latter of which is Russia's foreign intelligence agency." Yeah, you got it right. Paul Begala is proposing that we bomb Russia because the Rump supporters are not sufficiently ticked off for him. All right, now who could top that? Glad you asked. This week, the big red nose, and I really, truly did not want to do this. I swear I did not, but I just can't not do it here. So wait for it. The big red nose this week goes to Donald the Rump. Speaking with reporters on Air Force One the evening of July 12th, His High Orangeness said that his proposed wall along the U.S.-Mexico border would need to be see-through. One of the things, I'm quoting him here, one of the things with the wall you need is transparency. You have to be able to see through it. In other words, if you can't see through that wall, so it could be a steel wall with openings, but you have to have openings because you have to see what's on the other side of the wall. Okay, why? Because, quoting, when they throw the large sacks of drugs over, and if you have people on the other side of the wall, you don't see them. They hit you on the head with 60 pounds of stuff, it's over. So yes, we have to be able to see through his wall so that you won't get hit on the head with a 60-pound bag of pot. That's our commander-in-chief, our president, our national clown. Let's take a break. And we are back. All right, last week I said I was going to put off talking about the Rump's voter fraud panel because there are other things going on about voter rights and voting issues that I wanted to address them together, so let's get to that. And so, I mean, obviously the big recent headline on this whole issue involved the so-called Presidential Advisory Commission on Election Integrity. Those headlines hitting when on June 28th, the commission sent a letter to all 50 states plus Washington, D.C., asking for information on registered voters, including, and I'm quoting the letter here, full first and last name of all registrants, middle names or initials if available, addresses, dates of birth, political party if recorded, last four digits of social security number if available, voter history from 2006 onward, active and inactive status, canceled status, information regarding any felony convictions, information regarding voter registration in another state, information regarding military status, and overseas citizens. That is, they wanted to gather all of that data about every registered voter in the United States into one nice big federal database that they would control. Happily, a lot of states didn't take kindly to the idea. Among the more colorful responses came from the Secretary of State of Mississippi, who told the commission to go jump in the Gulf of Mexico in pretty much exactly those words. Now, there are a lot of varying claims about how many states refused to comply, with some saying only a handful did, while others claimed that only a handful didn't comply. The difference depended largely on how you defined comply. A good number of states said they would supply those parts of the information that are already publicly available, that is, the information anybody could get, although some of them added that they wanted to arrange with the feds to be reimbursed for the cost of sending this large amount of data. Some said they wouldn't comply at all, which it appears, by the way, they were apparently quite free to do, since the commission may have violated the Federal Paperwork Reduction Act, which requires that requests for information from the states must go through the Office of Management and Budget's Office of Information and Regulatory Affairs, which this one didn't. Ultimately, at least 44 states and Washington, D.C. won't give the commission everything it wanted. In the face of that resistance and a suit by EPIC, the Electronic Privacy Information Center, which was seeking an injunction against the gathering of the data, the commission put a hold on the effort, telling states to hold off submitting the information until there's a ruling on the EPIC suit. But while the gathering of the information was put on hold, the purpose of gathering it was not. There's very little reason to doubt that one of the purposes of the commission is to produce enough, and I use the word very advisedly, evidence to justify TheRump's claim that the only reason he lost the popular vote, which is something that really seems to stick in his craw, the only reason he lost the popular vote was that millions of people, maybe millions of undocumented immigrants, voted illegally. Giving extra credence to the idea that that's one of the purposes is the fact that Commission co-chair Chris Kobach said on July 19th that we may never know if Hillary Clinton won the popular vote in 2016. Because, he said, even if you can prove that a certain number of votes were cast by ineligible voters, you wouldn't have known how they voted. But for that argument to have any merit, you have to presuppose that you can show there were at least 2.9 million illegal votes cast, because that was Clinton's margin of victory in the popular vote. And that apparently is something that Kobach regards as quite likely to be, and I again use the word very advisedly, proved by the commission. But assuaging TheRump's easily bruised ego is not the only reason for the commission's existence. Its ultimate purpose is to continue and advance the right wing's attack on the right to vote. Indeed, opposition to the right to vote runs through the veins of a number of the members of the commission. Consider Chris Kobach. He is perhaps the chief architect of the right wing's attack on voting rights. As Secretary of State of Kansas, he has repeatedly tried to make it harder for Kansans to vote. In 2016, he illegally blocked tens of thousands of eligible voters from registering. He is, on another issue, he pushed the racist conspiracy that Barack Obama was born in Kenya. And in fact, in 2015, he said it was possible that the Obama administration might ban all prosecutions of African Americans. Then there's Hans von Spakovsky. As an attorney in George Bush's Justice Department and against the advice of career DOJ attorneys, he approved a restrictive voter ID program in Georgia. He is now at the far-right Heritage Foundation, whose president openly admitted that the group pushes for voter ID laws in order to elect, quote, more conservative candidates, unquote. Another member? J. Christian Adams. He is a longtime critic of the Voting Rights Act and has claimed that under President Obama, the Justice Department's Voter Rights Division didn't spend enough time protecting white voters. Oh, and don't forget Ken Blackwell, the former Ohio Secretary of State and now a senior fellow at the Bigoted Family Research Council. In 2004, Blackwell actively hindered minority voters from registering and then from voting in Ohio in order to support the re-election of George Bush. And he endorses TheRump's claim that there were millions of illegal votes in 2016. Now, if those kind of bios don't impress you, consider the group's actions. For one thing, Vice President Mike Notworth-a-Farthing's office has confirmed the commission intends to run the state voter rolls that it hopes to get against federal databases to check for potential fraudulent registration. A plan that experts say, and the commission must know, is certain to produce thousands of false positives with the intended loss of voting rights for an unknown number of people. The Brennan Center for Justice, a nonpartisan group focusing on voting rights, has predicted some outgrowths of the work of the commission. That is, if they're predicting this is the kind of thing the commission's going to recommend. One was a proposal to eliminate the Election Assistance Commission, which is responsible for, among other things, guiding compliance with federal election law. Predicting they're going to propose pushing national, state, and voter ID laws, and the fact that voter fraud, especially the sort that voter ID laws would address, is vanishingly rare, be damned, in order to embrace the fact that such laws disproportionately disenfranchise minorities, the elderly, and the poor. Predicting they'll want to demand proof of citizenship as a condition for registering, and supposedly Kobach, who tried to push this idea in Kansas, already has an amendment drafted to that end. And that they'll argue for mandating aggressive purges of voter rolls, which will be used to inflate claims of illegal voting in order to justify the other measures. That last part, voter purges, is already being pushed. The same day that Kobach sent the letter to the states about demanding information about registered voters, the Department of Justice also asked 44 states to send them information on their compliance with the 1993 National Voter Registration Act, the NVRA. That law mandates certain state agencies, such as the DMV, which is why it was nicknamed the Motor Voter Law, demands that certain state agencies provide citizens with the opportunity to register to vote, and also outlines specific conditions that states must meet before they can remove people from the voting rolls. The focus of the law, that is to enable, encourage people to vote by making it easier to register to vote. However, even though the bulk of the NVRA is about making it easier to register to vote, the letter from the DOJ was only about the parts of the law related to keeping up-to-date voter rolls, showing no concern as to whether or not states were actually doing enough to help people register. The result was that many saw the letter as a sign that the DOJ was gearing up to force states to kick people off their voter rolls. And just like the cross-checking that Notworth-a-Farthing wants to do, voter purges have also been notorious for producing false positives, leaving voters, often minorities, to show up at the polls to vote, only to discover that their registration has been wiped from the books and it's too late to re-register because the deadline has already passed. Chris Carson, the president of the League of Women Voters, said that, quote, "It's very clear that the intent is to purge more and more groups who possibly don't vote the way they want them to vote," unquote. But this goes beyond, well beyond the federal level. It's at the state level too, because even though U.S. turnouts for elections is already distressingly low, only 55.7% turning out for the 2016 elections, that's still too high for many Gopper-controlled state legislatures. At least 99 bills to restrict voting rights have been introduced or carried over from previous sessions in 31 states this year. The most common requirement is voter ID, demanding that voters produce certain specified approved forms of ID at the polling place in order to vote, even though repeated studies have shown such in-person voter fraud to be, again, vanishingly rare. But of course, stopping fraud isn't the point of these laws, any more than the second most popular requirement, demanding proof of citizenship in order to register to vote, is. The Brennan Center estimates that millions of Americans lack the necessary documents or ID, and effect felt disproportionately among minorities, poor folks, and the young. The point is then not to attack fraud. The point is to try to keep these disapproved groups from being able to vote at all. Consider what happens when Gopper state officials try to defend these laws as deterrents to fraud. When Missouri Secretary of State Jay Ashcroft, is his name, was trying to build his case for his no voter ID law, he could only cite one potential instance of possible fraud, that from 7 years earlier, and it involved registration, which is again something that voter ID laws would not affect. In 2013, Chris Kobach himself did a review of 84 million votes cast in 22 states and found just 14 instances of fraud. That's a fraud rate of 0.0000402%. But they won't stop because they don't care. They don't care about stopping fraud. They don't care about honest elections. They don't care about election integrity. They only care about winning elections any way they can, including twisting both law and logic to deny those who do not embrace their reactionary worldview, denying those people the most fundamental democratic right, the right to vote. And now they can count on help from the top. Since 2011, federal courts have determined that Texas's voter ID law targets people of color for discrimination. They've determined this not once, not twice, but 3 times. U.S. District Judge Nelva Gonzalez Ramos is considering if the Texas legislature's latest attempt to fix this is good enough. The previous versions have been knocked down in significant part because the list of approved IDs clearly preferenced some voters over others. For example, a gun permit was a recognized ID. A student ID was not. According to the plaintiffs in the suit, the latest version, quoting, maintains the same unexplained picking and choosing of acceptable photo IDs for in-person voting, accepting IDs disproportionately held by Anglo voters, and rejecting IDs disproportionately held by minority voters. So what happens? In stomps the Justice Department of Attorney General Jeff, I am not a racist, I swear I'm not Sessions, to declare that everything is fine, the law is fine, all suits challenging the law should be abandoned because the court has no basis for providing any remedy. And the fact that this version has the same flaws as the earlier ones, they don't care. More to the point, though, they do care because that disparate impact is the point. They will not stop, so neither can we. This is something I've talked about a lot over the years, and I expect I'll have cause to do it again. All right, I'm going to try to stick this in very quickly. As I was preparing the show, came the news that Senator John McCain has brain cancer. It's called glioblastoma. This is actually a very serious kind of thing. The typical survival time for that diagnosis is 2 to 3 years. The 5-year survival rate is merely 10%. Now, for all the disagreements I've had and continue to have with John McCain politically, philosophically, sociologically, whatever, there was a time when I always felt that whatever our disagreements were, I could look at John McCain and say, there's an honorable man in there. I don't know what happened to that honorable man these last several years, but for the sake of the memory of that honorable man, I will say I wish him well, I wish him the best. And my best wishes also go to his family. All right, we will see you in 2 weeks. We take the last week of the month off, so we will see you in 2 weeks. So for right now, you have the best 2 weeks you possibly can. And as always, peace.